So, with such an exceptional panel today, today's discussion promises to bring valuable insights into the global arbitration reforms and enforcement challenges. On that note, over to you, Shruti.
Thank you, Nikshita, and thank you, MCI, for the opportunity. Welcome, everyone. Welcome to Closing the Enforcement Gap in Arbitration. We're looking at discussing today lessons from global arbitration reforms. The enforcement gap essentially is the distance between the successful award and money in the bank. And that essentially is also the arbitration's credibility test. It's widened by uneven court support, expansive public policy defenses, sovereign immunity, sanctions, asset fights, set aside or annulment tactics. All of this drains time, energy, and of course, leverage. Around the world, recent reforms, as we've seen, aim to narrow this gap. Pro enforcement court practices in key hubs, including in Singapore or in the US or in the UK, legislative updates inspired by ancestral model law, recognition of tribunal ordered interim measures, emergency relief, tighter timelines, grounds for challenge, something that you would have heard over the course of past 2 days, and something that we'll also stress on today. So this panel essentially will distill what has worked, what hasn't, from jurisdictions closer to home like Singapore, Thailand, Japan, and further from home in India, but a natural business partner, the US. So without much ado, our goal today would be to bring a practical blueprint, concrete reforms, and case management habits that have closed this gap or potentially tried to close this gap over a period of time and protected party expectations and strengthen arbitration's promise of finality or something that we all look forward to. So, starting on that note, we all know that the background to most progressive arbitration regimes is ancestral model law. One of the most elusive concepts and exceptions or ground for challenge has been public policy. So, how it's localized over a period of time, something that personally interests me and is something that has been very often discussed, interpreted over a period of time in India. So, I think I would want to start closer home with Alessa. My first question would be to you. How common is the use of public policy ground for challenge in Singapore? And how and what do the courts really consider when looking at such challenges?
Thanks very much, Shruti. In Singapore, Singapore is also a model law jurisdiction. So the public policy exception, Article 34 2B2, forms part of Singapore law. And this also finds itself as a ground to refuse enforcement of a foreign award in Section 31(4) of our International Arbitration Act. So it says that a ground for refusal of enforcement of award is if it would be contrary to the public policy of Singapore. I wouldn't say it comes up often, but it can come up quite regularly. And I think this also features in many model law jurisdictions where it can come up where applicants try to use it as a catch-all provision, which follows after the other grounds that are more commonly relied on. For example, breach of natural justice. And what has happened in Singapore is that actually I don't think it's deviated very far. It's quite consistent with how the other model law jurisdictions have tended to interpret it, which is that the Singapore courts have consistently held that this ground is narrow and set a very high threshold. So one of the often oft-cited passage from a court of appeal case describes it as encompassing a very narrow scope and often used phrase is that it will operate in instances where the upholding of an arbitral award would shock the conscience or is clearly injurious to the public good or wholly offensive to the ordinary, reasonable, and fully informed member of the public. And then there are some other cases we go a bit more about to illustrate what are some circumstances which will fall within this narrow scope. And the court has described or illustrate, mention some examples such as corruption, bribery, fraud, anything that would, corrupt, subvert, or compromise the professional integrity, impartiality, and independence of the tribunal. So if there is, like bribery of the tribunal member itself, which, led to basically an unfair award being produced.
Would you like to What are your thoughts on this public policy exception, how it's perceived in your jurisdiction, and the global enforcement regime that you've seen over a period of time?
Thank you, Shruti. Thank you so much for inviting me onto this panel today. As Alessa mentioned, the public policy grounds is not often perhaps mentioned in Singapore, but in Thailand, it is quite a common ground to resisting enforcement. However, the Supreme Court in Thailand has recently, in the last, I would say, maybe 5 or 6 years, been rendering decisions which are sort of more pro-arbitration, and so trying to define public policy on narrow grounds. So there have been a number of Supreme Court decisions which have upheld arbitral awards on the basis that intervening with the award would be contrary to the objectives to resolve the dispute by arbitration. The arbitral tribunal has discretion to consider the facts of the case, and the court should not repeatedly review the arbitral tribunal's discretion on the admissibility and weight of evidence. But in terms of the actual definition of public order and good moral, there is no specific definition. And the Supreme Court decision recently, in the last 2 years, they had a very interesting decision whereby they did attempt to try and define public order and good moral. And they said that for this ground to be established, it must be shown that an arbitral award is based upon facts or legal applications that affect the fundamental legal system or common sense relating to fairness. And they try to give examples of such circumstances, which would include an arbitral award in which a party is ordered to perform its obligations relating to sale of narcotic drugs, which is quite interesting, or an arbitral award in which a party is ordered to perform its obligations based on the contract obtained by corruption. So as mentioned by Alessa as well, the Supreme Courts in Thailand are also trying to narrow the definition of public policy grounds to corruption to make it more aligned with the ancestral model law. But in certain instances, the Supreme Court has also rendered decisions where they have allowed parties to rely on public policy grounds. And I would say that it's really in sort of three categories of cases in which this has been allowed. So one is relating to either limitation or prescription periods in Thailand. So if the award is contrary to Thai domestic law when it comes to limitation and prescription periods, that could fall under the public policy grounds. Another area is in relation to interest. So again, if the interest awarded is contrary to Thai law, that could be a ground which the parties can rely on under public policy. And then the final one is where the case of ultra petita. So if the award goes beyond what was requested in the submissions by the claimant, then that could also form a ground under the public policy. So I'll just stop there for now. But happy to comment on any of those issues.
This is just a very small subset of what we see in India, and I'm sure Pallav will have a lot more to say on this. But Pallav, I'll come back to you later. Sudhanshu, what, according to you, would be what would be your view on the use of public policy exception in the US? And what are the other challenges that you see practically in your practice?
Sure. No, thank you, Shruti, and thank you, everyone. I'm very happy to be a part of this panel. So I think it's, what Alessa and Emmy described sounds very familiar in respect of how US courts have traditionally treated the public policy doctrine, whether as a ground for set aside or challenge of awards, or whether ground for refusal of enforcement of awards. Now, the US is not a model or jurisdiction, as I'm sure all of you know. It has developed in a very unique way. The FAA, the Federal Arbitration Act, is the principal statute used in respect of challenge or enforcement of awards. And it's a very old statute. I think it's 1925 or 1935, and not much has changed since then. The FAA, obviously, there have been some amendments. The FAA incorporates the New York Convention, So in respect of any applications for enforcement of foreign awards, US federal courts and state courts rely on the New York Convention. So in that sense, the public policy exception as regards to enforcement of awards is a part of US law. But as a ground of set aside, this is not a part of US law, at least not statutorily. There is no basis under the FAA to challenge a award on the basis of public policy. But that said, there is a trend, historical trend, I would say, for the past 50, 60 years, where public policy has been invoked as a ground for setting aside of awards under the FAA, and US courts in rare instances, and you will find these examples extremely rare, maybe not more than a few, where US courts have recognized that there is a public policy exception, and I think they call it they call it a well-defined and dominant public policy exception, as opposed to something called a national policy or political interest of the United States, which may be a ground to vacate an award. Now, as I said, this is very rare, so I can explain maybe with the help of some examples where courts have explained what public policy is. And one of the most famous cases that is always frequently discussed when talking about public policy in the U.S. is called the Parsons versus Racta case. And this case is pretty old, but it concerned award rendered against a US company in Egypt out of a company's contractual obligations to perform certain out of a construction project in Egypt. Now, this was 1967. So, in 1967, there was a war between Israel and the Arab states, due to which all US nationals were forcibly expelled out of Egypt. So this company could not obviously perform its contractual obligations, and but an award was rendered against it nevertheless in Egypt. So it applied to US federal courts for vacating the award on the ground that it is contrary to public policy of the United States because the state of Egypt expelled all US nationals, and therefore to enforce the award would be contrary to US's political and foreign policy interests. The court actually refused enforcement of the award, which might sound surprising to some. I would say, I mean, at least based on my experience of in India, if this would have occurred in India, probably the courts would have vacated the award. But in the US, the award was still enforced because the court said public policy is not equivalent to political policy or foreign policy of the United States. Public policy must be looked at in the very narrow context of arbitration and not in the context of US politics or US foreign policy. And therefore, as I said, the context is dominant, and the word that they use is dominant public policy, and it's very exceptionally defined. One of the examples where US courts have vacated awards is, I think, what Emmy also alluded to, is on interest. I mean, that is something that the US courts rigorously monitor because the US law does not, for example, recognize the concept of penal interest. So any interest which is not contractually stipulated or which is not provided for in the which goes beyond what is obvious, and if the contract is governed by, let's say, English law, and English law has a particular conception of interest, but if the award goes beyond English law and awards interest which is not provided for in English law, the US courts would not enforce such an award because the US, as I said, does not recognize the concept of penal interest. So I think those are the very limited exceptions under which US courts operate. And although public policy is frequently invoked, especially in investment arbitration context, it's invoked, but it's never successful. For example, there was a recent case, I think, against Libya, I mean, not very recent, but maybe like 10 years ago, where Libya was, and probably still is, there's a civil war in Libya, right? And the US has adverse, with respect to foreign policy, the US and Libya are not aligned. And the court said to enforce a war, basically Libya's, I think Libya, it was Libya which argued that to enforce an award against Libya would be contrary to US's public policy, but the court refused it because it said public policy, not foreign policy. Yeah, so I'll leave it at that.
Thanks, Sudhanshu. That's very helpful. I think contextualizing public policy exceptions and challenges is very important, and that's what we understand from Alessa, Emmy, and you. But interestingly, in India, over a period of time, we've seen how this definition of public policy and the scope has changed. So, Pallav, what are your views on how practically these public policy challenges work in India, specifically over the past decade?
Yes, thank you, Shruti, and thank you to IMC and MCIA for this opportunity. Happy to be here. So yeah, public policy has a lot of history in India, and it has had its ups and downs. As you're aware, we started off with Renu Sagar, which I think gave a very crisp definition of public policy. It says anything that pertains to fundamental policy of Indian law, uh, that should be the explanation for public policy, and especially in the context of foreign awards. And then subsequently, with passage of time, there were some judgments which said no, we will add patent illegality to it. I think ONGC was the judgment. And then there was a law commission report, and then certain judgment, Justice Nariman came into picture. He said, okay, the judgments don't apply, which broadened the scope. And then it narrowed it back down to fundamental policy of Indian law. At the same time having that notions of justice and morality. I think those are pretty much what in law or in judgments what they say what public policy of India should be. In terms of practical approach, I think the application has been that look, we will not stop enforcement of any award because it tends to violate some provision of Indian law. That will not be the definition of public policy of India. It has to go somewhere in the root of the matter, the root of Indian law. And that's what the fundamental policy of Indian law actually means. And various instances of this principle has come in HEMA judgments. One locus classicus, which has been applied all across high courts, is the Vijay Kalia judgment by Justice Nariman, where the objection was taken that if you enforce this award today, then I will have to violate Foreign Exchange Management Act in order to comply with this award. The court said no, you can't, just because some regulation is being violated of FEMA does not mean that this will fall in the category of fundamental policy of Indian law, consequentially public policy, and therefore I will not allow you to use this as a defense. So there the award was enforced, and Delhi High Court, Madras High Court have followed this, and various challenges to enforcement have failed. Except I recall there was one judgment of Madras High Court which allowed the objections on the grounds of violation of FEMA. But in that case, they said that it was actually a loss of foreign exchange to the Indian coffers, and therefore it will fall in the category of public policy and violation of fundamental policy of Indian law. So that's where the law stands today, that every other ground that you take or every, you know, small violation of Indian law here and there will not come in this category. And the stand is to that extent pretty much consistent with what Emmy and Alessa have already shared, that, only cases of bribery, fraud, in all of those cases will the courts intervene on these grounds. In fact, that Madras High Court judgment, which I was just referring to, also had ground on fraud. And both those grounds put together, the court set aside refused the enforcement of the award. So as on date, I think it's pretty much consistent to say, and Vijay Kalia holds the field, that, every violation of law or every such allegation or regulation will not really help the cause. you really need to go something that show something that goes to the root of the matter or root of the Indian provisions, and then only the courts will refuse enforcement of foreign awards.
Besides public policy exception, one of the key considerations that the parties are now looking for in closing this enforcement gap globally under New York Convention or even otherwise are the sovereign immunity considerations. So I think moving in and also probably tying together both public policy and sovereign immunity considerations, what would really be the Indian stand, for example, uniformity of approach or even otherwise? According to you, Pallav. And I'll start with you and go back to Alessa.
See, under the Indian law, if you look at the foreign sovereign immunity defense, that the source of law is CPC. Section 86 of the Civil Procedure Code talks about protection to sovereign acts. But judgments have regularly clarified that these sovereign immunity defense does not work in the commercial law space, and that will not come to rescue. In fact, recently there was one judgment where some consulate or something got some construction work done in their office, and they were seeking, and there was an arbitration award against them for some compensation, and they sought to invoke this defense of sovereign immunity. And the court said nothing doing since it's a commercial case. So this is a sovereign private act, and therefore we will not allow you to take the defense of sovereign immunity. And this has been the stand before also. I think 2019 there was some Afghanistan or Kazakhstan consular issue, and then I think one case law we used to read in our law school is some 1982 American legal case. I think there also it was first time given, and I think the way I see it or way I have seen the courts doing it is that courts always want to narrow down this exception and say only very limited cases where the sovereign is actually acting in capacity of a sovereign outside a commercial law space, then only we will give that protection. And that protection is also in form of some kind of a test that you have to first seek permission from the central government, and what are the considerations that the central government must look into before granting that permission. So that's also more of a procedural safeguards than actually saying that there's a blanket stay and that you can't reach out. So it's more in that regard. Not in the Indian context, but something in the UK context. I think something recently some interesting happened last sometime in April, where in the Davis case, in India took this defense before the UK that we have not given up on our sovereignty and not subjected ourselves to jurisdiction of UK courts. In that context, the UK courts held that just by signing of the New York Convention does not mean that you have given up your claims, and to that extent, agreed to jurisdiction of the UK courts and waive of sovereign immunity. So I think that's something I can recollect from a UK context. I think Australian courts also said something similar. But in the Indian context, these are the only instances I can think of.
At least in the Davis litigation, it's spanned across the world. There have been different views on similar issues over a period of time and decades altogether. I think from this, I'll want to request Sudhanshu to chip in. What are the key sovereign immunity considerations on enforcing arbitral awards against foreign states in the US? Is it different for federal or state courts? What is the uniformity of approach there? And like you said, federal FAA is a very ancient act. So has there been a change in approach of US courts while interpreting it?
Yeah. I mean, I was absolutely. I'm going to answer that, but I was curious from Pallav's remarks to know what role, if any, does the government, like for example, the Ministry of Foreign Affairs in India, play with respect to sovereign immunity considerations. For example, do courts seek the intervention and assistance of the Indian government when there is a suit against a foreign state in India? And why I ask that question is because when you look at the US, that's how traditionally it was prior to 1976. And I gathered from Pallav's remarks that that's probably the Indian state has some role to play before courts whenever a foreign state is sued. And that was exactly the case prior to 1976. Before the Foreign Sovereign Immunity Act was passed and the law on this matter was codified, in that sense, there was a concept of absolute sovereign immunity, which means that unless a foreign state has consented to being sued in the United States, a litigant cannot initiate a litigation or suit against a foreign state. And unless the State Department went before the federal court and said that okay, it's okay to proceed against this state or this state-owned entity, the suit was not entertained. But all this changed obviously in 76 when the Foreign Sovereign Immunity Act was passed. And although the act is called Foreign Sovereign Immunities Act, that's a misnomer because it's most of the act is about exceptions to foreign sovereign immunity. And one of the most important exceptions is called the arbitration exception, which means that if a state has consented to arbitration in a contract or in a treaty, and if an award arising out of that arbitration agreement is enforceable in the United States under the New York Convention, under the Exit Convention, under any other Panama Convention, for example, then the concept of foreign sovereign immunity does not apply.
Take it just as interjection. I think it applies to both investor state uh, disputes awards and the commercial arbitration awards.
Absolutely. It applies to any award which is capable of enforcement in the United States. That's the exception. And that's the arbitration exception, which is basically a test or a threshold for subject matter jurisdiction. But there is another threshold, and which is for attachment of assets, and which is the primary concern, right? In enforcement cases, the concern is how do we collect the award. So there is another exception which is called the commercial exception, which also I heard Pallav alluding to, which is that if an asset is being used for certain commercial purposes, that asset does not have foreign sovereign immunity. So, for example, a diplomatic building or a diplomatic premise that belongs to a sovereign state enjoys sovereign immunity protection. But other types of assets, which are commercial in nature, do not, which is why you saw, I think it was in the US and Canada, uh, the award creditors in the Devas case suing Antrix, and I think it was some other case where they were seeking to attach assets of Air India. At the time, Air India was owned by the state, right? It's probably no longer owned by the state, but at that time it was owned by the state. So that was because the assets in question were commercial in nature. So those are the broad exceptions. I mean, there are, we're probably going to spend the whole day if I'm going to talk about FSIA. But one more key point is that since you mentioned the Devas case, right? Devas case is not an enforcement case against the state, right? Not against the Republic of India. It's an enforcement against the state-owned entity called Antrix Corporation Limited, which is owned and controlled by the government of India. Now, in those cases as well, the FSIA recognizes an exception for jurisdictional purposes, provided it is established that the state-owned entity is an alter ego of the state, right? And that's the test that most courts grapple with. And to prove an alter ego, I mean, it's again, there's varied jurisprudence, different circuit courts have different tests and different metrics. But courts generally look at the degree of control that the state exercises over the management of the state-owned entity, over the assets of the state-owned entity, over the decision-making of the state-owned entity. And if it is established that the state-owned entity is an alter ego, then the FSIA states that there is no sovereign immunity and the suit can proceed. Uh, for the Devas case, you also may have seen that there's a recent Supreme Court decision, and that decision is a little bit strange because, by the way, that case is not concluded. So that decision is a little bit strange because in the Ninth Circuit of the US federal court system, the Ninth Circuit also requires that in addition to this arbitration exception and service of process, they require that in respect of state-owned entities, there is an additional jurisdictional threshold of minimum contacts, which is to say that the state-owned entity must have minimum contacts with the United States. So in that case, the Ninth Circuit said that Antrix does not have minimum contacts with the United States because it doesn't do business in the United States. It's not incorporated here. It does not have assets here. Does not have employees here. It does not have a branch office here. But the Supreme Court, I think it was in June, rejected that argument and said that the FSIA does not statutorily require an additional test for minimum contacts, which is generally applied in the non-sovereign context. And I'm sorry if this is all sounding very confusing, but it is very confusing because it's all over the place. And so that case now is remanded back to the Ninth Circuit Court for determination of the question whether Antrix is an alter ego of the Republic of India, which is, I think, the crucial threshold question in all cases where a state-owned entity is sued. So I think I'm going to leave it with that.
No, I think from both Pallav.
Can I just take 1 minute? Just want to read out the provision which Sudhanshu was referring to. As Sudhanshu, it's 86.3 of the CPC, and it says,
Yeah.
except with the consent of the central government, certified in writing by the secretary to that government, no decree shall be executed against the property of any foreign state. So the central government will have a role to play.
Yeah, so this was the position before 1976 here as well, but yeah, that's because it's political in nature, and I mean, we are dealing with commercial awards and even in this investment arbitration context, we are essentially dealing with a commercial relationship in most cases. So that's been done away with in the US.
The New York Convention, we'll just draw some difference between enforcement and execution that lies really at the core of what we see, at least in India. Going to Singapore and Thailand, I think one thing that I want to specifically know from Alessa and Emmy on sovereign immunity exception is, and putting it in perspective, because in India specifically, statistically, large number of foreign awards for enforcement come from Singapore. Even in public procurement related contracts from government agencies, including something very similar to Antrix, there will be provisions under the contract that identify Singapore as seat. So, for all those contracts that are arbitrated with Singapore as seat, these sovereign immunity exceptions become very important if an enforcement has to be obtained across the world. Alessa, what are the views of sovereign immunity as exception by Singapore courts, including the SI?
So I think actually very recently there were at least two decisions issued by the Singapore courts. Not necessarily substantively discussing the exceptions to sovereign immunity. But for context, the Sovereign Immunity Act in Singapore is modeled after the UK one. So I think the similar exceptions apply. So there is a general immunity for states. There is exception insofar as the state has agreed in writing to submit a dispute to arbitration. So it means that if you can argue, if a state could argue that actually there was no such arbitration agreement entered into, then the state immunity, should. And this issue has arisen in the context of as Singapore being an enforcement court after setting aside proceedings had taken place in the sea courts. So very recently, I think just about under a month ago, that one of the cases that was issued by the SICC, our International Commercial Court, related to enforcement proceedings brought about by the UCOS claimants against the Russian Federation. And because basically there were already decisions issued by the Dutch seat that were determinative of the issue of whether or not there was an arbitration agreement in summary. But before the SICC, what the Russian Federation tried to argue was that the state immunity applies because they were not precluded from raising the argument for immunity to apply under the State Immunity Act. So a distinction had to be drawn between a general argument against the tribunal's lack of jurisdiction under our International Arbitration Act and the state immunity defense. But the court rejected this argument. The court actually applied the holding that was of the Court of Appeals decision in the Deutsche Telekom and India case, which was also before a Singapore Court of Appeal, where the court actually held that the doctrine of transnational issue estoppel can apply in the context of state immunity defenses. So if a decision, by final and binding decision, has been issued by another court in relation to issues which underpin the question of whether there was an arbitration agreement in writing had been entered into. The party is precluded from raising these arguments before the enforcement court. And on this basis, the parties which were seeking to resist enforcement of the award, the arguments were actually rejected.
That's very interesting, and of course very recent as well. That brings me to Emmy. Emmy, what are your jurisdiction's considerations specifically when it comes to considerations of sovereign immunity exceptions? And is it different for domestic awards? Is it differently approached for foreign awards that come to enforcement?
So in Thailand, it's similar to what Alessa said in terms of the state or Thai government has entered into a contract which has agreed to resolve disputes by arbitration, then that would be considered as an implied waiver. However, in terms of the history of arbitration involving Thai states and government, some of you may be aware of the very famous decisions involving Hopewell Holdings as well as Walter Bao, where the Thai government and state did not have a favorable decision in the arbitration, which led to very convoluted and complex enforcement proceedings taking place in Thailand. And that resulted in various legislative changes being made, which some of which have now been changed again to make it more pro-arbitration. However, at one point in the history of arbitrations in Thailand, arbitral dispute resolution clauses were not allowed in state contract as a result of that. So Thailand has quite an up and down relationship with arbitration when it comes to involving state entities. And one has to bear in mind that when it involves the Thai state or Thai government, we need to be very sensitive and also be aware that certain enforcement proceedings involving the state has to go to the administrative court of Thailand as opposed to the court of justice. One thing I do want to touch upon, which is relevant, and it comes up quite often in practice, is the use of anti-enforcement injunctions or anti-suit injunctions in Thailand. In fact, I'm currently involved in an arbitration, Thai-seated arbitration involving an Indian party, in which there have been inquiries as to whether or not anti-suit injunctions can be obtained in Thailand or anti-enforcement injunctions. And the short answer to that is no, or is very rare in Thailand to be able to obtain an injunction. And even if a foreign court has ordered an anti-suit injunction or anti-enforcement injunction or a foreign tribunal, it would be very difficult to enforce that in Thailand because the Thai courts, there is no treaty that Thailand has entered into which has a reciprocity of enforcement of foreign judgments. So likewise, with any injunction orders that are made by foreign courts or tribunals, Thai courts will look at it afresh, and that could take a long time. And it is very rare in practice to be able to obtain such an injunction. So it has no binding effect whatsoever in Thailand, and that's something to bear in mind for parties.
In Thailand, would these injunctions, foreign seated injunctions, be it arbitral tribunals or courts, they still have persuasive value?
Sorry, Shruti, could you repeat?
They still have persuasive value. We've seen in this is
yeah.
quite.
It would have value in the sense that the Thai courts will certainly take it into account, but it's certainly not binding. So in practice, they will take it into account as evidence.
That's very interesting to know. I think what we've covered two very important points. One is public policy exception, the other sovereign immunity exception. And what I can see is there is no consistency when it comes to sovereign immunity, but public policy more or less is a narrow exception, which the courts also are interpreting as such. And legislations are moving ahead with a period of time to see that they become more pro-enforcement and close this enforcement gap. So, as last question from me, just thinking out loud, what is the single reform by, let's say, 2030 that would shrink the enforcement gap in your jurisdiction or according to you in any other jurisdiction or globally? Alessa, please start.
I thought very hard about this, about whether there's one magic bullet that would really help. I don't think there is one particular reform. I think ultimately it will boil down to um convergence or consistency in decisions across jurisdictions really help in terms of predictability for enforcement, and also in terms of, really different jurisdictions really upholding the spirit of what it means to be part of the, to be a signatory of the New York Convention, and, enforcing awards if they should be enforced. So, I mean, just by way of example, when you're talking about anti-enforcement injunctions, just last week there was quite a helpful decision, what I thought was quite a clarificatory decision issued by a Singapore courts about anti-enforcement injunctions. Essentially, a party tried to apply for an injunction to stop enforcement of an award worldwide while setting aside proceedings were going on in Singapore. And actually, there were already enforcement proceedings going on as the award had been remitted, and then the remitted award came out, and then another setting aside application was started to set the remission award. And I think one of the helpful parts that the court highlighted was that, I mean, it dismissed the arguments raised by the applicant, because the applicant tried to argue that, this by trying to enforce the award while the award is being set aside, this outs the jurisdictions of the Singapore as the seat court, and so on and so forth. Other things I thought was helpful that the court mentioned was that, by signing up to arbitration and signing up for Singapore as a seat, which is the New York Convention, New York Convention country, the under New York Convention, enforcement court is not bound by a seat court decision to set aside arbitral award. And, ultimately that by agreeing to Singapore's seat and agreeing to this entire regime, the party had also agreed to an arbitration regime to which the enforcement court would retain the discretion whether to refuse enforcement on the ground that the award had been set aside by the seat court. So they can't just say that, that there should be, it should be prevented from enforcing the awards elsewhere just because the appeal on the setting aside should. So yeah, I think ultimately there should be holding the spirit of, the New York Convention and the model law, and all this would help towards, a regime that would be arbitration.
So definitely bring strategic litigation that we really enjoy to an end, probably. I'd want to hear Emmy's thoughts on this. Emmy, what is the single most reform that you think by 2030 could help streamline this enforcement?
It's always difficult when you ask somebody to give one answer to such a broad and complex issue. But I think that the one single reform that would be needed in Thailand is to define public policy. So here it's called public order and good morals. But as I mentioned earlier, with the string of Supreme Court decisions, which are sort of it's certainly helpful in the more recent decisions, they've tried to define it, but to have a more specific definition of this would help with predictability, as Alessa mentioned, consistency as well, and it would make it more in line with international best practice. So just having a clear definition of public policy and limiting it to cases which involve illegality or corruption or fraud, I think that would be the single reform that would be very helpful. And I want to cheat slightly, Shruti, and just because reforms do take time, particularly in Thailand, I think what parties can do right now in terms of trying to make an enforcement as successful as possible in Thailand is to bear in mind what the Supreme Court decisions have shown us so far. And so, as I mentioned earlier, circling back to, when the courts have allowed parties to rely on public policy. So making sure that, we're avoiding, ultra petita type of situations. So making sure that the awards are strictly within the scope of relief that is being sought, making sure that, the Thai law element is considered early on, because often parties just don't think about it until the enforcement stage, but really, in order to make it successful and have money in the bank, as you mentioned, Shruti, I think it's important that Thai law on limitation periods, interest is dealt with early on. So I think these are some practical things that parties can already consider when thinking about enforcement.
Well, thank you, Emmy. I think we carry it forward to even see insights from India and the US. Sudhanshu, what's your view on the single most reform that's needed by 2030?
I mean, I think sorry, I'm going to echo the others. It's very difficult to say. I think any sort of reform, at least in the US, we are probably talking about more of a judicial, clarity in judicial precedent or clarity in how different, courts interpret different requirements. I think that is something that is more pressing in the US rather than a reform of the law as such, because a reform of the law, at least in the federal context, is going to be very difficult given, where we are uh, in this country. But I think, yeah, as I said, there is several issues. There are several issues on which there is a split between different courts, different federal courts, as to how they interpret requirements. I think one example, as I explained, is under the FSI, in the foreign sovereign immunities context, whether in addition to service of process, whether there is a requirement of the foreign state-owned entity to have minimum contacts with the US. I think there is a lack of clarity on that because some circuit courts have said that the state-owned entity must have minimum contacts, as I said, and that was the decision in the Antrix case. Whereas now, I mean, now the Supreme Court has clarified, but this issue may come up, later in a different context. So I think in that sense, having more clarity and consensus across the circuits and federally would be more beneficial. I think there are other examples as well, but I'm going to leave it at that.
Yes, we have your pick from the basket that needs clarification and clarity. Thank you. What about you? I know we've talked about, I asked about single reform, and you're going to tell me the same thing. We already have an arbitration amendment bill pending, and there have been drafts that have come out. Besides that, practically speaking, what's the single reform, be it the legislature, judiciary, or even administratively, that you think can streamline, think this enforcement gap?
See, my answer is not was never about the amendments or anything. See, post 2015, the endeavor has to be the endeavor is that we be more consistent about it or narrow it down. I think that's recognized everywhere. The high courts are conscious of this fact, and of course, the law will be applied as when it comes, and various awards will come and they'll apply the law. But I think one major struggle that people who have the awards in their favor, they're coming here to execute. I think one struggle that they will always face is delay. And of course, the most simple answer is get more courts, get more judges, have dedicated courts. But of course, that's not the answer also. I mean, easier said than done. We have constraints of infrastructure and money is required, all of that. So maybe some way of streamlining the hearings of these challenges could be one way to resolve the issue, to dispose of these matters quickly, could give some relief to the foreign investors or people of the awards in their favor. Another remedial measure that could be undertaken, I mean, recognizing the fact that there is some delay in in the judicial system, could be to come up with some provisions for interim relief so that you prevent dissipation of assets during that time. Obviously, that's not there in Section 48. It's not there in the New York Convention. The only interim provision is that you can suspend the enforcement if the challenge is pending in the seat court. But considering the fact that India takes a lot of time to go, I mean, that day I was at the High Court. I had my own matter where I was opposing enforcement, and it turns out there was another matter which was pending from 2019, some enforcement of some award passed in Australia. So, I mean, if it's taking that much time, at least some interim provision should be there to protect the award holder so that he can eventually, when he wins it, he can execute it. So I'm just as a more preventive strategy. I know the CPC provides for execution, and the execution, if you see that you're defrauding the creditors, then of course you can take those measures. But prevention is always better than cure. So the law will trickle down. There are recent judgments. Pro enforcement bias is read into it by Vijay Karya. Something similar in other jurisdictions. So all those things are there, but I think on the application, on the hearing of those challenges, I think we can do something about it. That will be a great change that India can bring into its own ecosystem and do wonders.
I think we don't have any questions as such, but I'm just going to close and I have a sticker on with my take on one reform. I think that should just be adverse costs. The moment you put adverse costs, the higher they are, the parties are disinclined, and the enforcement gap obviously shrinks to only include something with merit. So thank you, everyone. Thank you, panelists, for joining us. Thank you to the audience and everybody who's come here. I've just have to check. There's one question from Rohit. I'll take the liberty of asking it to all the panelists. Please feel free to respond. When it pertains to the enforcement of foreign awards, the procedure followed by most common law jurisdictions, including the UK and Singapore, would involve recognition of the award in ex parte action, followed by set aside proceedings. Now, they talk about the obvious advantage of the procedure to seek ex parte freezing order. It's a long question. Sorry, I'm just babbling for now. Is there a tangible benefit to an approach like this? And the next question that follows is there an area where India would benefit from aligning with the procedure followed in most other common law jurisdictions? I think, uh, Pallav, that is best answered by you. It's in the context of Indian arbitration.
Yeah, I think under the UK law, I think section 101, you can simpliciter ex parte apply for, assuming it to be a degree and then apply. And then the other side gets a right to set it aside by moving an application. So I think the hint is towards that we should also under section 48 go with that provision. I don't, I see in the Indian context, I don't think that's there. That should be there because even for us to seeking a setting aside will take a lot of time and a lot of prejudice can be caused by that time. So I might as well go with the regular New York Convention procedure in the Indian context. See, I think we've long debated it, and in the last constitution that is also before the Supreme Court, this question would often come up that should we simpliciter adopt what's happening in Singapore or UK, or recognize our own problems and come up with our own solutions. So my understanding is that yes, they are very good precedents and there's a lot to learn. But we should just be also conscious of the situations we have here and the conditions, and then suitably amend or adapt or discard whatever learnings that we had from the other jurisdictions. So, in short, my answer is, in my humble submission, opinion, I would disagree with that suggestion.
Yeah, I think we don't have any more questions. And thank you, everyone. Thank you, panelists. Thank you, IAMC, Nikshita, and MCI for having us. I hope you all had a good time, and I'm taking something away from the discussion today, specifically on sovereign immunities.
Thank you.
Thank you. Thanks, everyone.
Bye.
Thank you.